The Chapter 7 trustees have quite a bit of authority to do things. And they, number one, can collect and reduce to money property of the estate and close the estate expeditiously as is compatible with the best interest of the parties. So the estate is really the assets of the debtor. So, in theory, at the time the case is filed, the trustee takes over everything except for those assets that were listed as exempt. The trustee also has to has to be accountable for all property that is received. So if the trustee takes a car, for example, and that car is going to be sold at auction, the trustee is responsible for taking care of it. Put insurance on it, make sure it doesn't get damaged. Also ensure that the debtor performs his intentions as to the retention or surrender of property of the estate. When there is a secured creditor, like in a house or a car, you have to declare what you're going to do with it. Are you going to keep it? Are you going to reaffirm? Are you going to return the property? Or are you going to redeem it? And redeeming it is when you pay the value of it. It was a motion to value is what would have to be filed. Generally, once the intention is made, you have 45 days to act on it. So if you indicate that you're going to turn the property over, you got 45 days to do it. If you're going to be doing any motions, you got to file motions. I usually suggest if motions are going to be filed, do it before the creditors meeting so that the trustee knows what's going on. Trustee also is responsible for investigating the financial affairs of the debtor. Anything that relates to this case, and think back what we were talking about. The debtor has to basically disclose to the court their entire financial life, and the trustee can go a long way to doing that. They can find out about any kind of financial account that they have, talk about financial interactions between themselves, the debtors and family members, other business members. They always take a look at the bank statements to see if there were any big movements of money in the previous 3 months. And if there is, then they'll ask about it. And if sometimes they look for patterns. If they see money going same amount to a certain place, to a certain person, they'll ask about that. What is all this about? Is it repayment for a debt? Is this person a friend or family? So the trustee really has quite a bit of authority to dig into the financial life of the debtor. When a creditor wants to prove that they have a claim, in case there are any assets, they file what's called a proof of claim. And if there are assets in the case, the trustee is required to go through the proofs of claim to see if they're valid. If the trustee disagrees with some of them or doesn't believe they're valid or have any basis, the trustee can object and it goes to a hearing in front of the judge. If advisable, the trustee can oppose the discharge of the debtor, but not as to a particular debt. In other words, if the trustee believes that the debtor is hiding assets, is not cooperating, is not playing by the rules in general, the trustee can file a motion saying, hey, judge, this person is just not following the rules. This is a voluntary case. They didn't have to, they didn't have to file it, but they did. And therefore they have to adhere to the rules. And this person is not adhering to the rules. And therefore, please dismiss the case or allow the case to close without a discharge. All right, let's see. Unless the court orders otherwise, furnish such information as concerning the estate or the estate's administration as requested to or by a party in interest. If the business of the debtor is authorized to be operated, file tax returns. So sometimes trustees can actually take over and and operate the business of the debtor. They don't usually like to do that. And the reason is that there's some liability involved. And if they step in and want to do that, then they really have to take over. So about the only time they would do it is, let's say, for example, that there is a business and the person has a project that is almost complete, that is this close to completion, and it's going to be a big payout. And the trustee can use that money to pay creditors. Well, under the circumstances, the trustee really could take over and continue the operation of the business. But it's tricky because the trustee is responsible for the business also. And a lot of times they don't want to take on that liability. And at the end, they have to file a final report with the judge, letting the judge know if they collected anything, if they distributed anything, and get final permission to do a final distribution. Now, avoidance powers. The trustee has an amazing ability to undo things. Basically, I tell people, we have to look back 2 years from the time that we're going to be filing that case to see if there's anything that the trustee can undo. And that includes, well, let's go through it here. Preferential transfers to or to benefit a creditor, and a transfer can be from the debtor to a creditor. Let's say there's a creditor, especially friends or family members, or creditors that the trustee wants to keep a good relationship with. If the creditor pays off somebody at a time when they're not paying off other creditors, the trustee can go back, get the money back, and spread it out more evenly. Preferential transfers on for or on an account of an antecedent debt owed by the debtor before the transfer was made. Transfers made when the debtor was insolvent. See, that's the main thing here. The code is set up so that all the creditors get treated equally. So if at a time when the debtor wasn't able to pay everybody, they were paying just someone, just one creditor, to the detriment of others, the trustee can go back and undo those payments. The exception with that is secured creditors. So even if you haven't paid your credit cards for a year, you can still pay your house payment. In fact, you should. Secured creditors are treated specially. I always, unless the client wants to give up the collateral, always tell the clients, got to keep making the payments on that collateral, the house or the car or the furniture, if it's a furniture payment, things like that. Generally, any payments or transfers within 90 days of when the case was filed can be undone if it's substantial enough. The trustee's not going to mess around with $100 payment to a credit card company. That's just not enough. If it was $5,000, they would probably do it. If it was $1,000, they might even do it. They can avoid preferential transfers, which enable the creditor to receive more than the creditor would have received if the case was a case under Chapter 7 and the transfer had not been made. That's a little confusing. It's kind of rare. All right, and fraudulent transfers, it's a different category, and that's transfers to friends or family members. The word fraudulent is not really intending to denote bad acts or illegal behavior. Okay, but it comes under the general heading of fraudulent transfers. So that's transfers to insiders, friends or family members, transfers within 2 years of the filing date. So in other words, if your debtor gave someone a car that was worth like $10,000 within 2 years, then the trustee could undo it. So that's transfers within 2 years of the filing date, especially if it was intended to hide assets, and that's either from the trustee or from creditors. And if it was intended, or let's see, if the debtor received less than the reasonable equivalent of value. So in this case, if in the last 2 years they sold a car for $100 that was worth $10,000. Okay, especially if it's to friends or family. The trustee can object to that and undo the deal because it wasn't a fair deal. It wasn't arm's length. Now, if you sell a car at a fair value to a friend or family member, and it's a good value, in other words, the numbers check out, the trustee really probably is not going, well, they're really not going to complain about that. The next question was going to be is, okay, you sold this car, where'd the money go? And see if they have it anymore. Again, all of this assumes that all this happened at the time when the debtor was insolvent. And insolvent basically means at a time in which they are unable to meet their normal obligations. So if everything's going fine and they're making their payments and they've got their credit card payments going and they're not behind on anything, and they sell and they make this transfer or sell a car to a friend or family member, and then 3 months later their business burns down and they have to file bankruptcy after that. That changes things a little bit because they did not make the transfer at a time when they were insolvent. They were solvent at the time. Postpetition transfers. Anything, it is very important to let people know that the world freezes at the time they file the case. From the date that case is filed, that filing date, you can't do anything. You can't sell things. You shouldn't really buy things. You cannot incur new debt. I have heard one particular trustee, after she found out that a person sold a car the week after the case was filed, she asked the person, "Why did you sell my car? That wasn't your car anymore. That was my car. Who did you sell it to? I'm going to go get it." Those were almost her words verbatim. So it's important to tell people is that especially during the time between when the case is filed and we go talk to the trustee's office, don't do anything, okay? Continue to make your house payment, continue to make your car payment. Don't buy stuff, don't sell stuff, just cool it, okay? Until we get past the creditors meeting. And at that point, things can come back to normal again. But I always tell them during the bankruptcy, don't do anything financially, buying and selling, anything like that without checking with me. All right, liens and fines and penalties. The trustee can avoid liens and undo even some state court activities. And if they do avoid liens, they generally, for example, judicial liens are no problem for a trustee. So if there's a judgment out there that has a lien against a person's car and otherwise the car is paid off, that is not a problem for a bankruptcy trustee. Again, we were talking about operating the debtor's business. They can operate the debtor's business to finish goods in progress, to sell perishables if a person owns a grocery store, for example, to complete contract work that might benefit at the end, or to enhance the value of the business that the trustee might want to sell. So that is all something that they can do. However, they're hesitant to do it because they take on the risk of the loss. They're responsible for filing the taxes. The trustee is responsible for paying the taxes. If there's additional costs of completion, if there's not enough money, if the company doesn't have enough money there to be able to complete it, then it's not going to be completed. And a potential liability for claims, so the trustees are generally very hesitant to take over someone's business because there is some risk involved. Sale of assets. A trustee should only sell assets that will generate sufficient proceeds to ensure a distribution to unsecured creditors, priority or general creditors. So, like in the Orlando area, if a trustee can't collect $2,000, they're probably not going to bother because it's not worth their while. because of everything that they have to do. If a trustee collects any money, they have to send notices to all the creditors. Hey, I got some money, file your proof of claim. Then after a period of time, the trustee reviews the proof of claim. If there are any that they need to object to, they object to them. It goes to a hearing. And then after all of that is settled, then they make a distribution according to a pro rata share, depending upon the size of the individual debt. And they finally get final approval from the court. And they have to give 20 days notice of the sale of the assets. Sometimes the sale involves the trustee selling the assets back to the debtor. So, and where that happens is, let's say in your particular state, someone is allowed only to have $2,000 of personal property, and they have $4,000. Okay, the trustee can say, all right, well, you're $2,000 over. You need to buy the overage back from me, or I'm going to start taking stuff. And what happens is, if it is agreed upon, the trustee files a notice of sale of assets, in essence, selling the debtor's stuff back to them. And they'll sometimes do it as sometimes a lump sum at a discount. Sometimes it's on a payment plan. And as we said before, the trustee can sell assets free and clear of judicial liens. They have to try, for example, they could sell a car that has a regular lien, a secured creditor on it, but they would have to have enough money coming in to be able to pay off the amount that's owed on it. If it's close, the trustee's not going to bother. But if it's a big difference, like if the car is worth $10,000 and the lien is $5,000, the trustee will probably sell it, pay off the lien, and then use that $5,000 to pay creditors. The trustee can even sell jointly owned property, like real estate, even tenants in common, joint tenancy, and even tenancy by the entireties, husband and wife property, also is available to be liquidated. Now, this varies a lot from state to state, so you got to know what your particular laws are in this case. And the tenancy by the entireties, the husband and wife property, you usually don't see that. At least in Florida, we don't see it because of the terrific homestead exemption. But in other areas where the homestead exemption isn't that terrific, if one spouse files the bankruptcy but the other does not, then you could find a trustee maybe wanting to sell joint marital property. It really depends on the exemptions. So, before you file your first case, you got to learn the exemptions that are allowable to you. Now, even though the software that you're probably going to buy is going to have a function where it's going to help you apply the proper exemptions, you still have to understand the basics of it. And the exemptions come from state law, if they're state exemptions, and you can look that up in your state statutes. Some states will opt to use the federal exemptions. So and some states use a combination of both. So that can be a little bit tricky. So you need to really look into the exemptions of your own particular state to know where you're standing, and you have to have a good grasp of that before you file your first case. Like we said, the trustee can sell secured property, but they have to get enough to pay off the lien. Now, how do these trustees get paid? They're actually independent. They don't work for the federal government. The trustees get $60 per case, even if there are no assets. So they get $60 a case to review the case and to hold the creditors meeting. If they do collect something, and this is why trustees can be so aggressive, they get 25% of the first $5,000 that is disbursed. They get 10% of the next $45,000 after that, 5% of the next $950,000 after that, and they get 3% of anything over $1 million. So if they get lucky, I mean, every trustee is waiting for that big case. Because if they had a big enough case where there are big enough assets, frequently they retire, and that's it. I know several who have over the years, and the other ones are still waiting for their $1 million case to come in.